All right, cheers, guys.
To a good week, but also
challenging week.
One of the funniest decisions I've read in a long time. We're going to talk about a couple of decisions, but...
Wait, but before we get there, do you remember what tomorrow is?
Joe's birthday?
It's Joe's birthday, everyone. Birthday, Joe.
Thank you very much. I turned 56 years of age.
Shh, never tell.
Never tell.
I don't mind. It's okay.
Proud of it.
I know.
Yeah.
I moisturize. It's fine.
Oh, well, that explains everything.
So, yeah, this was actually a funny decision. But it has, you know, it's funny because it's funny for a lot of things. So it's an October, it's a recent decision of a matter that was heard on appeal October last year. But it's just funny. It's just funny because, you know, we're 30 years plus out as lawyers. So when I read like this,
Brings back memories.
And some Crown attorneys like this judge is biased and the appeal is based on bias. And it's like, they just didn't grow up in our era.
No, they have no clue.
So bias in a judge is, we'll get into it a little bit more, it's a very complicated argument to make on appeal. They were successful, well, no, excuse me, unsuccessful in this case, because it was a Crown appeal of an acquittal.
Right.
Yeah, they were unsuccessful. So ultimately, let me just read one thing. It's important. So to be blunt, the perception of the public is critical to the efficacy of the justice system. The public, in turn, must have confidence in the court's ability to deal with the civil, criminal, and other disputes in a rational, civilized manner. The dignity of such a system is undermined at society's peril. In my view, repetition of what occurred in this proceeding would contribute to the erosion of public confidence in this institution. The Crown has not discharged its very heavy onus in the circumstance of this case to establish actual bias or reasonable apprehension of bias on the part of the trial judge. So what's important to start off is that there is a very clear principle that the perception of an impartial trier of fact is very much at the core of our judicial process and the criminal justice process. And the dignity of such a system can be undermined sometimes when goes on in court, which isn't good. That said, this wasn't one of the most serious cases. Right. And it was actually quite amusing. So we may actually go through this a little bit slow.
Okay, let's start it by saying what the case is. So it's R.V. Fraser, F-R-A-S-E-R, 2023 at NSSC, which is Nova Scotia
Superior Court.
Superior Court. Excuse me for coughing. 45. Oh, great. Thank you. Our producer.
Thank you, Max.
Dedicated water boy.
Getting over a cold. So
2 glasses. That's impressive.
I know. Double hand.
I'm not
Which
holding
one?
the-
Which one?
Double fisting.
Yeah, I'm not holding the third one for you.
So this was a Crown appeal of an acquittal. And so the Crown alleged that the judge exhibited bias, that he, after only one Crown witness had testified, the main complainant, that he said, I think you need to seriously question your case over lunch before we continue.
Right.
But the comments from this judge are hilarious.
Yes.
And I think show a lot of...
We're going to have to pause because something's vibrating.
yeah.
It's not my pacemaker.
No, despite your age.
Okay, so let's just break this down a little bit because it is funny. And it's going to harken back a little bit to Michael and I.
The olden days.
Doing trials at Old City Hall, 1994, 95, and for other lawyers who may watch this who are a little bit older than us. But anyway, so this poor accused, well, look, he was a bit of a rogue in his law office. So he was a lawyer, and he was charged with criminal harassment and alleged to have been engaging in threatening conduct directed at the complainant.
He was also a lawyer.
Also a lawyer.
He was also a lawyer, but the managing partner at the firm, who reasonably in all the circumstances feared for her safety, contrary to the criminal code provision for criminal harassment. And so both the accused and the complainant were partners in the same law firm, and the complainant was a member, if not the managing partner, while the respondent was not, but was a senior lawyer at that firm. And it looks
And
like...
one of the things that the judge noticed happened was that the law firm split into factions. So there was a number of witnesses the Crown was going to call, and the judge recognized that there were certain people who took sides at the law firm in terms of what they were, whether it was a law firm or any other firm.
Yeah, and
this often happens.
The dynamic at the time was the firm seemed to be going through a difficult time, and there may have been, the firm was dissolving. I'm not sure if it was, but that seemed to be the hint that there was internal turmoil going on. So anyways, so the decision of the judge acquitted the accused, and the court, the appeal from the Crown to the summary conviction appeal court was basically that the judge erred in law by making comments indicating an inclination to acquit immediately after the first of 5 Crown witnesses, thereby raising an apprehension or an appearance of bias or actual bias in favor of the accused and other stuff. But the central issue was the bias.
Can I just...
Sure.
Can I just read the next little bit that I've highlighted that I thought was really funny?
Yeah, that was the key.
He says to the complainant, the main complainant, the one who says that she was being harassed, "You can step down now. You're good. I'll just encourage you. If you testify again in court, you work on impartiality. When Mr. McDonald, one of the lawyers, is talking to you, and you're referring to him as Don," they're talking about the accused, "instead of calling him by his name or Mr. whatever, you call him the accused. It doesn't bode well, just so you know."
Yeah.
So this is a comment by the judge to the complainant after she testified. He's like, "Yeah, you know what? You could have done better.
Yeah,
you could have done better."
But
not impressed.
But the judge actually wanted. So the case was booked for a 1-day trial, and he kept going with the complainant's evidence, and rather than breaking for lunch, wanted to keep going to make sure the evidence wasn't broken up. So good for the trial judge. And then he did make the comment saying, you may want to...
Says to the Crown.
Yeah.
The prosecutor.
So following that, the judge decides to get into a conversation with the Crown attorney. And basically says, well, she's the named individual. And the judge was curious about how many witnesses were yet to come. And the judge...
It was supposed to be a 1-day trial, wasn't it?
It's supposed to be a 1-day trial. So the judge said, look, the crux of this is her. She's the named individual, and we can call it the victim for whatever sake she is right now. And the court says, so I have no idea where this is going, but it's not going well in terms of conviction. I'll tell you this now. What you have here, and I'm going to keep an open mind for the rest of it, but you may want to think this through over lunchtime. You have an aggressive and annoying partner at a law firm who likely wants his way. He's been there a long time, and you have a very emotionally unfit, unprepared person who's managing partner, one of 3 managing partners. Seems to me, I'll keep an open mind, I haven't heard the rest of the evidence, but it seems to me that a lot, and perhaps all of what was discussed in the realm of her job as one of those managing partners, he just keeps going on, blah, 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 I think you have a very steep hill to climb. I'm not so sure you want to spend the rest of the afternoon climbing that hill. I think the prosecution's got to think this through. It's a choice you got to make. I've dealt with you for quite some time now, so I suspect I know where this is going.
Oh my God.
So let's pause there for a second. So you have...
I wish I was there.
Yeah. You have a complainant who testified, who's really, and he's right, that's the main complainant because it's her...
complaint.
It's her complaint.
And also... this is a criminal harassment charge, so there's 3 elements that they identify that are subjective, and only the complainant can make out those elements of the charge. And that is, was she subjectively afraid?
Well, she has to reasonably fear for her safety in all the circumstances, and then it has to be objectively
reasonable.
Yeah. So that's why it's getting at it. But I just want to talk.
And no matter how many other supporting witnesses you can have about what they heard, there's subjective elements that count directly on the complainant.
Yeah. So look. So yeah, it's a troubling comment if you're a Crown attorney, and certainly the Crown attorney took umbrage to that, and after being told by the judge,
and was a bit combative, and so this plays into it later.
Not until later on, but the judge then went through the elements of the offense, and they have a number of back and forths. And the Crown says, Your Honor, it looks like you've I have a significant concern here. It looks like you've made your decision. Not before argument, but before the Crown has even presented its case. It sounds like the decision's already made. And they start to get into a battle.
Oh, did so, did not, did so, did not, did so, did not.
And it's, I mean, this is available on Canly, and it's actually quite amusing to read in terms of combativeness between, well, combative assertiveness, I think, from a judge. And so he brings up something, the judge brings up something very important, which is case management. Because our courts are overwhelmed. And I found it very noble that a judge would say, after hearing the core of the complaint, you can bring in other witnesses, which...
But do you really want to go ahead with
we're going to get into oath helping in a little bit. You can bring in other witnesses, but when the main complainant doesn't meet the quality of evidence and the courts are overwhelmed, this is supposed to be one day, and they're saying they have like 4 other witnesses, and the defense wouldn't even have called... You're not going to get through it in a day. I can't blame the judge for saying, are we really going to, climb this hill?
Is this something that you hadn't experienced in your life?
I think a few times we've had these experiences. Many times. Like judges saying, Mr. Burry, are you sure you want to call your witness? Or are you sure you want to call any other evidence?
Or sometimes after the Crown's case, it's like the judge is looking at you like, look, dude, you're not really calling a defense.
You're not calling a defense, are you?
Or sometimes they've said to the Crown, what's that expression? This something won't swim. There's an expression I remember it being said a number of times. Yes. But we've been there.
We've had the signals.
And this is years and years and years ago, because there's a political correctness now that plays through the court system that God forbid if it did back down.
Oh, you'd be
these judges would have all been terminated.
Judicial council.
But the reality is they did manage the docket.
Right.
And they did reach out and they did say sometimes to a Crown attorney going, look, I've heard the first witness who's the most crucial witness. Like, what are we doing here? Yeah. Literally, we've heard this before. And then sometimes you actually would then take a break and have a discussion and sometimes work it out, or the charge would get withdrawn, and you've got effective case management.
Right. Well, we were talking about the judge that used to tell us at Old City Hall, okay, guys, I'm on the golf course by 1 o'clock. Get in the hallway, work this out. I'm sure it'll be a good deal once I'm done with it.
Which isn't the right thing to do.
But it's case management.
But,
But I've also seen, like, I've been present for 2 cases where the prosecutor recommended acquittal. And so there is a value to that, saying, like, do you really want to rethink your case?
Yeah, so I think on so what happens eventually is the judge, lets the Crown call its case and calls the rest of the witnesses. The defense doesn't call the defense, and the guy's acquitted. And the Crown appeals solely on the basis of bias. And the appellate judge in the Superior Court Summer Conviction Appeal Court basically says it wasn't the best day for either.
Right, I know, that was a great comment.
And
it wasn't the most noble.
It was interesting to see the combativeness by the Crown attorney, who's a long-time experienced Crown attorney, and whatever the judge was saying. But at the end of the day, the judge, arrives at the opinion that in all the circumstances, the judge was very much still alert to the issue.
Well, he continually said, my mind is still open. I'm just saying,
I'm impartial. That's all. My mind's open.
You make your decision. And so an interesting thing that happened, though, is that the Crown, the prosecutor, kind of, they said that they were going to challenge and they were going to ask the judge to recuse himself.
Well, they brought a recusal motion at trial, which the judge denied.
So, so you bring a motion saying, we think you should excuse yourself. These are the reasons we think that you're not capable of continuing the trial. And generally, judges are keen on admitting that, although some have.
No, some do. Some do. Yeah. So in this case, the Crown brought a recusal motion. The judge said, no, I know what's involved in the test for recusal.
He was on a committee about judicial bias.
And I have a lot of experience in recusals and bias, and this ain't one of them, so forget it. Right. So I'm not going to do it. But the Crown got to call its case, and it was over. And it really... It's funny because of how you read it and them bumping their heads.
That's a circus,
And then, to some that this is like an unusual thing, whereas we grew up in an era where you had to fight with judges. They'd yell at you. Right. A judge who was upset would dismiss a docket.
Fall asleep. You'd have to wake up. It was
crazy shit that went on, right? Oh, yeah. Like, I remember, I'm not going to say him, but God rest his soul. I mean, he was a fun judge to be in front of someday, but the Crown prosecutor and this isn't the one who was in Newmarket, this is a long time ago, was so mad at the Crown, the first case, the witnesses were late.
Yeah.
Dismissed it right away.
Yeah.
You know, but when you get to the heart of it, it's very important, the principles that they talk about here is that, you know, the presumption of judicial impartiality is incredibly important, and there is an extremely strong presumption of it. So that means that in order to overcome a verdict on actual bias or apprehension of bias, it's a very high threshold.
But they describe the difference between the two. One,
talk about that.
It's incredibly difficult to prove that somebody is biased. So most of these claims of bias go to, would a reasonable person perceive a potential bias and question the legitimacy of the decision? So it's just a perception of bias that most of these cases are heard on, and then you have to consider whether or not that perception is, you know,
legitimate,
based on a reasonable person, and you know, it's still a pretty high bar because the judges are listening to all the evidence. They're making decisions based on demeanor. And most of the people who read these decisions are reading them in writing. They're not literally physically present in the courtroom.
Right.
And there's a big difference between that. And that's why there's a deference given to judges, because they're by the appellate courts, because the judge was there and present and able to witness a bunch of things. And so that's one of the important things people reading about cases later have to keep in mind. There's a very big difference. Even reading transcripts of statements given by complainants, I like to watch the video because you can get a lot more from what's going on. And sometimes there's like actions that aren't described in the transcripts, and listening to the demeanor and the tone and all this other stuff. So, you know, there's
a dynamic that plays out during the course of the trial that's lost in a transcript.
Exactly.
And so when you have a feel for a case and you have an experienced judge, you know, sometimes this will happen. It doesn't always mean there's bias.
Right.
You know?
They say something at the end, though, that I think is really important here, too. They say, sadly, I've concluded that some reasonable informed person referenced above, even if that person, I'm on paragraph 64, even if that person would not have concluded that it was probable that the trial judge was biased, they would nonetheless walk away with their respect for the justice system shaken.
Right.
Well, so here the judge, and again, we're not really being critical of any of these parties, but the judge did chastise the first witness. But I have sympathy for the fact that this person refused to call them a name. And we're in cases where actually people are quite polite. They refer to them as their first name or their last name, Mr. This, Mr. That, or by their first name, not the accused. When somebody actually says the accused, and I've had that in a couple of cases, you know, you're pretty, there's something going on there,
There's a
right?
use of language to try and imply guilt.
Right.
Yeah. I mean, there's, you know, I think there's a bit of pathology with somebody who refers to the...
And in this case, it was coming
individuals,
from
the
somebody
accused.
who's a lawyer, so she knew what she was doing.
She knew what she was doing. She
You
knew
know,
exactly what she was doing.
But, you know, clearly there's chastising or critical discussion about the first witness, and there's clearly criticism about the case of the Crown. And so, yes, I can see how reading this and looking at it, how this was not the best example of...
It was not the classiest.
Not the
performance.
classiest one. That said, I have a lot of sympathy, again, for judges with a lot of experience, some old school judges with a lot of experience, looking at who's the accused in a courtroom, goes like, seriously? Why are we f***ing here?
I know. And
we've experienced this. Like, we've experienced judges in the course of a trial to go, and very much in favor of something accused, going, I don't understand why we're here.
yeah, and I think I appreciate when they're blunt. And that's one of the things, like, for outside people who aren't involved in the legal system, they have a lot of trouble understanding the etiquette and so on of calling the prosecutor and the defense lawyers, calling each other my friend, and like all of these you know, phrases that are used, is to keep civility in the court and to try and keep people from blurting out things that are inappropriately worded and so on, right?
Yeah, and you know, we've said this before, and I think I like to try and say this. I think overall, although, you know, you could look at a lot of our podcasts and see how critical we are about things, I think consistently we've said we should be very proud of the criminal justice system and the judiciary and the prosecution system that we have in Canada. We have a high level of respect for each other. We have a high level of civility. We treat everybody generally with respect. We just finished a trial this week with an excellent judge, an excellent Crown attorney on a very difficult and emotional case, who everybody rose to the highest level of professionalism, and I don't think anybody left the courtroom, regardless of what the decision will be when we get it at the end of May, to feel that they weren't heard or treated respectfully. And that is a credit to our system. And that sets us apart, in my respectful view, of other jurisdictions. And, I always tell an old story when it's I forgot what year it was, but there was we lived through a couple of strikes where the guards at the jails were on strike. And so that would spill over to the courthouse because you don't have some of the court staff that are security are part of that union. And I'll remember a case where, a judge in Brampton had sentenced an individual to 10 years. I believe it was on either an aggravated assault or attempt murder. And then the judge realized and said, "Mr. So-and-so, I'm very sorry. I just realized I don't have any court cards here. I don't have anybody around. Would you mind sitting in the prisoner's dock while I try and get somebody to assist?" Because once sentenced to a jail sentence, you then have to be brought down to the cells and eventually taken to the jail. And the person said, "No problem, I brought a book, Your Honor," and sat in the dock, and then he conducted another trial. That gentleman sat there for 4 hours.
Wow, that's
and then
so Canadian.
Then Peel police officers had to come, brought him into the cells, and transported him. And I always tell this story because I talk about the civility of our system, that even on a sentencing in such a serious case, this person sat in the box. And if you go to a courthouse in Toronto or any of the outer-lying areas, it's not a zoo. Yeah. It's a respectful place where everybody is treated respectfully, which is why it leads me into one other comment.
Well, things can get out of hand. Like, I remember they interrupted a preliminary hearing once, and they brought in a person who was probably mentally ill or whatever. He created a great disturbance.
But that's mental illness.
That's mental illness. Ruckuses are par for the course.
Was it Justice Mara Green?
Yeah, Mara, and she
was delightful. She handled it so well. She kept everything
Oh,
calm.
she's fabulous.
Yeah, and so it doesn't always go so smooth.
No, but that's somebody sadly who's suffering from mental illness. But even in in cases where I've been on serious organized crime cases or project cases or murder cases, I mean, everybody generally, there's threats and concerns, but we have a good system, and part of that also is because of our sentencing regime. Our sentencing regime is not insane. Right. We don't treat people like animals. We don't put out 500-year sentences. We don't litigate these cases in the media, and because of that, we have a much more humane system. And frankly, our society benefits as a result of it. But now I've done my praise for the system. People might go, "What the is that? Is that Joseph?" He never praises the system. But anyways, can a judge ever be not biased? I'm just curious about that.
So this came up as a result of reading this case. There is one thing, though, that I want to say from the case we were just looking at. I found one of their last paragraphs to be really important. They say, to be blunt, the perception of the public is critical to the efficacy of the justice system. The public, in turn, must have confidence in the court's ability to deal with civil, criminal, and other disputes in a rational, civilized manner. The dignity of such a system is undermined at society's peril. In my view, repetition of what occurred in this proceeding would contribute to the erosion of public confidence in this institution. So even though he wasn't overturned, I think that point is really important because this balance between having public confidence and administering justice in a way that the public might not understand is a very difficult balance to achieve. And that leads to what you were just prompting me to talk about.
But I'm going to say, because I actually started off with that sentence, but I think what would be important is if the public actually came out to watch trials. I think it would be so wonderful for the public to be more informed what goes on in our courts, and then have an actual real view of how trials are, how justice is meted out, what goes into a sentencing, what goes into an acquittal, what goes into a conviction. I just wish the public would come out.
I had a weird roller coaster. I started out getting interested in law because I found the logic behind law, and how if something is true in one place, it'll be true across the board. That logic was so attractive to me that I had like all this faith, and we have an amazing system in Canada in terms of comparison to others. But then you see injustices, and then you're just like, oh my God, it starts to tank, right?
Right.
But the longer you spend going to court, the more you understand that, yeah, there's injustice that happens.
It's a human system.
But our system is quite incredible, and it does follow.
It's hard.
Logic.
We go through a lot of difficulties. We fight hard in the court. There are sometimes, not always are we with a judge that we think is the best on a case, or there are decisions that are made by certain judges that we're very critical of. That said, overall, I've always said this, I don't think anybody truly wants to create a wrongful conviction, but there are misguided things that have happened, and in our past we've had a lot of atrocities with wrongful convictions. And the one area that we do see where things have been tunneled too far is with sexual assault and domestic cases, where we think they are ripe for wrongful conviction.
Yeah, where it's deemed to be a gender issue.
Yes, and there's all sorts of horrific that goes on with that. So I don't want to lose sight of that. But can a judge, it's just an interesting question for this discussion on our podcast, truly ever start a trial impartial?
Impartial. So as we were looking at this case, it reminded me of, and I'd done a video about this, we had a Supreme Court Justice, Bertha Wilson, who was I think the first female judge who was appointed. And the very last decision she ever wrote was a case called Lavallee, RV Lavallee, 1990, 1 SCR 852, that's for Max. And this is a very important case because it's the first case in Canada.
Extremely important case.
To recognize battered woman syndrome as it is not a defense, it's just access to a defense of self-defense.
There was also a very important case because of that about expert evidence.
Yeah, and right before she issued her decision, allowing Lavallee to be acquitted on this basis, even though Lavallee didn't testify herself, there was an expert witness that was the subject of the appeal. Can an expert witness testify about this when the accused isn't subjected to cross-examination on the very same issue? Too complicated to get into. But she gave a speech called "Will Women Judges Really Make a Difference?" And she talks about when she was first appointed, and they went, yay! The public, feminists were saying, now we've got a female judge, now things are going to go better for women. And she was like, but my hands were tied because I have to be impartial.
Right.
And so it's a very lengthy...
This is actually an extremely important point.
It is, yeah. Mm-hmm. And one of the ways I got into looking into what was going on in our legal system and connecting with you was because I was looking at feminist activism that was going on. And so this is precisely what she's talking about, the expectations on her as a female judge. And it should be female judge. It annoys me she said women judges, but that's just...
Whatever, that's the time.
It's just grammar. Yeah. It's just grammar. So she said, indeed, as a woman judge, anxious to respond to these changes, I wondered to what extent would I be constrained in my attempts to do so by the nature of judicial office itself. And so then, and I've talked to people who have a different take on this than I do, but I'll just tell you the highlights for me. She talks about Socrates. He defined the essential qualities of a judge in the following manner. 4 things belong to a judge: to hear courteously, which is what we were just talking about, being courteous, to answer wisely, which we hope they can do, to consider soberly. That's difficult when you work in law.
Some do. Some not so much.
And to decide impartially. So she summarizes those concepts. Then she starts quoting mostly British philosophy and starts talking about, can anybody really be impartial? And so my take on this speech is that she says, she quotes all these people saying, nobody can truly be impartial. And then she goes, therefore, it's okay if I'm not. That's my take on it.
I think truly what she was expressing at the end of the day is that everybody comes to a case with a particular bias.
We all have baggage.
We all have baggage.
Everyone comes,
So you're going to have life experience, and it will frame who you are. Yeah. But the power of being impartial, the overarching principle of that once you ascend to the bench to be a judge and therefore judge your fellow citizen on serious matters, you then have to try and transcend any of those particular characteristics, much like we tell a jury. And you can see, you know, the wash that goes over a jury's face when they realize we are judges. And I've always believed that I think, you know, you can try and be as impartial as possible. But, you know, I think most of the time they can, some they can't. But most of the time, the majority of time, you know, you can try and do that. And we've seen, we just had a case play out where I did submissions and the judge was talking and say, right to the accused, this is a very difficult case, human trafficking case. I was saying right to the accused, this doesn't smell good for you.
That was said
Right.
in front of the jury?
No, this was judge alone.
Judge alone.
Oh, okay.
Not going to name
I thought you
anybody.
were talking jury.
One of my cases.
No names.
We're going to have a decision eventually. And basically the judge was saying, this doesn't smell good for you. I absolutely do not believe you. But I have to be impartial. I also have to understand proof beyond a reasonable doubt. And I do. And I also recognize what your lawyer said to me about all the problems with the Crown's prosecution.
It's a lot of self-checks.
But I trust the judge implicitly. I know him for a long time, and I know no matter what, he will arrive at the right decision. But you know what?
He's
It's
going to weigh
interesting.
things properly.
But it's interesting because I believe that on balance, I think this client's going to be acquitted, but I think the judge was using it as a teachable moment.
Yeah.
You know, saying, and said things like, you're a bright person. You're a bright young person who can have a very bright, wonderful future. I don't know what the you were thinking, but, you know, you can totally have a bright future. And basically there was a lecture there, a teachable moment where I think he knows he has no choice but to find the person not guilty. Hopefully, God willing. But it was interesting because I don't find that offensive in any way, shape, or form.
There's a very interesting quote that I just want to visit from this. And the entire speech by Bertha Wilson is really interesting. But another moment that stood out for me, Judge Rosalia Bella, who at the time was chair of the Ontario Law Reform Commission, she says, also doubts that judicial impartiality is a realistic requirement. That's a quote from this speech. And that's kind of interesting.
Why?
Because Justice Bella, if she doesn't believe impartiality is a realistic requirement, she was on our Supreme Court of Canada.
She just retired, yeah.
Yeah.
It did a great job. She was on Court of Appeal, did a very good job.
Oh, yeah,
I mean, we may disagree with some of her decisions, but overall I thought she was a very, very good judge. And you know what? Was impartial. I think what they're trying to say is you can never say anybody's 100% impartial. I
guess it's kind of like saying I never lie.
Right. It's like, you know, you come with your baggage, you come with your experiences, but what you will do is push all that aside to make the right decision on the facts. And apply the law. I think that's where they get with it. But it's extremely important. And when we think about it for this discussion, because it was just some of the language used in this trial was very amusing. And we don't get
laugh out loud from
we don't often get to read decisions that are like this or trial decisions. But, you know, it brings back something which I think is very important for us to always talk about is, you know, the importance of impartiality in our system. And overall, it does a very good job of that, regardless of people's own biases when they're judges. I just think it does overall a pretty good job.
And I think sometimes, you know, you can have a really amazing judge who makes a decision that does have bias because maybe there's something in it that they, you know, connects with them in a certain way or whatever. And, you know, that's just human. And that's why we have courts of appeals.
Right. We have appellate courts. And I just think where our concerns rise, and we often talk about this a tremendous amount in our podcast, is where other things creep in, other interest groups and other influences creep in and try and push a certain narrative from a particular interest or point of view that can then cause certain issues, and that's where we have to be really careful in Canada.
And that's what I've kind of gotten passionate about too, is that there's been almost a request and a demand from our legal system that they become biased in certain ways.
Right.
And so
That's a good way of putting it.
that's why it's important to talk about this. And also, you know, through Lighthouse, my nonprofit, with people who've been falsely accused, wrongfully convicted, I get a lot of people claiming that there's, you know, oh, the judge was biased, and they don't understand the legal system well enough, and the legal language and the reasoning behind it.
Right.
And so they assume there's bias. And so I think it's an important topic to discuss, you know, what is and isn't bias, and why there's some deference to judges, you know.
It's not an easy job.
No.
It isn't. It isn't.
And there's actual bias, and there's perceived
And there is human,
bias,
but that's
right?
why we have appellate courts too.
It is, and statements from this court that talked about, you know, that's why I led off with it and you ended it with is, you know, the dignity of this system is very much undermined when something happens like this. But sometimes it does, and you know, we can't take everything too seriously. Until next time.
Yeah.
I know. Like, subscribe, hit notifications, leave comments.
Share.
And wish him a
Share.
happy birthday.
Happy birthday, me. All right. Thank you, everybody, for watching and viewing.